Good morning, everybody. Glad to see everybody. It looks like everybody's bright and early today this morning. With that, let me go ahead and let's call this board meeting to order. If I can have Ms. Taylor, please call the roll.
Certainly. Chairman Vasquez,
Present.
Vice Chair Schaefer,
Present.
Member Gaines,
Here.
Member Cohen,
Good morning, President.
and Deputy Controller Stowers.
Present.
So we have a full quorum, everybody present this morning. With that, we will start with the Pledge of Allegiance. If I can get you all to please stand. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, with that, members, once again, since we're still doing this virtual meeting here, I want to just remind us all again, and you've all been real good about this. And for those that might be logging in, especially today during the hearing, please, your patience is graciously appreciated as we all began this meeting, because we all pretty much share one line. So if we could just remember to just please be recognized so we can have our transcriptionists clearly state who's making motions, who's seconding them, and then document it all very as accurate as possible moving forward. Really appreciate your patience with that. And with that, I want to open it up for some opening remarks. I know Member Gaines wanted to say a few words. So, and I see his hand up. Member Gaines, go ahead.
Yeah, thank you, Chair Vasquez. I appreciate it. I just wanted to give a little update in terms of the Caldor fire in El Dorado County, not too far from where I live. And it's burned over 100,000 acres. And the blessing is that there have been no deaths. There have been hundreds of structures that have been burned down, including people's homes. And it's 9% contained. So for many, many days, there was no containment of the fire. So the fact that it's 9% is showing some improvement. And I think, the fear is that it goes into other communities like Pollock Pines, Placerville, and even South Lake Tahoe. So I'm hoping that CAL FIRE can contain it as best as possible. They're working very hard and doing a good job, I think, of trying to contain it. The smoke is out of control in many parts of the county. The basin, Lake Tahoe Basin, the air pollution index has been as high as 800. I think it's 500 to 600 right now. But thank you for asking about it earlier, Tony. And then finally, I just wanted to also announce that it's our 36th wedding anniversary. So Beth and I have been married 36 years today. And to celebrate, I'm at the BOE meeting and I'm loving it. Thank you.
That's true commitment. 36. I think you might have me by a few months. And thank you for those for the update. Yeah, because we were out there in Tahoe for the Assessors Association. I thought the air quality wasn't that bad, but just for the viewing public, when we're throwing out these numbers, 500, 800, what's good quality?
I think it's isn't it under like 60 or 50? I think is considered air quality, and I think around 100 is considered moderate. So it's very unhealthy.
Saying 500 to 800, right?
Yeah, very unhealthy. I've got a friend that lives up there, and he's actually down in Yosemite with his wife. He just got out of town.
Is Yosemite a lot better?
Yes.
Okay. Thank you. I see another hand up. Ms. Stowers. Go ahead, Ms. Stowers.
Thank you, Chairman Vasquez. Controller Yee and myself are like to say that our hearts go out to those individuals who are impacted by the current wildfires. We also want to let you know that there's various tax relief through property tax, which you can find information on the BOE website that will connect you to your local county assessor. Tax relief regarding income tax, like filing and tax deductions on the Franchise Tax Board website. Tax relief related to sales and use tax on the California Department of the Tax and Fee website. When you go to those websites, I recommend you just do a keyword search disaster, and those pages would pop up for the information that you would need. Also, I know since many of these areas are declared a disaster area, tax staff from those various agencies are out there currently and from the county providing information like obtaining your tax records if something was destroyed in a fire, and just kind of recreating your financial records. So I just wanted to make that available to those who are currently listening and let you know if you need any additional service, you can always go to the state controller's website at scl.ca.gov. And we have a resource page there for these type of items, including COVID-19 assistance. Thank you.
Thank you for that information. Yes, for all those that are viewing and listening in, and I know several of us who have our own websites, including the BOE. Please by all means reach out if there's anything we can do to assist. With that, let me ask Ms. Taylor if she would please announce our first order of business.
Our first order of business is an announcement regarding public teleconference participation. Good morning, and thank you for joining today's Board of Equalization meeting via teleconference. Throughout the duration of today's meeting, you will primarily be in a listen-only mode. As you may know from our public agenda notice and our website, we have requested that individuals who wish to make a public comment fill out the public comment submission form found on our additional information webpage in advance of today's meeting, or alternatively, participate in today's meeting by providing your public comment live. After the presentation of an item has concluded, we will begin by identifying any public comment requests that have not been received by our board proceeding staff, with the AT&T operator providing directions for you to identify yourself. After all known public commenters have been called, the operator will also provide public comment instructions to the individuals participating via teleconference. Accordingly, if you intend to make a public comment today, we recommend dialing into the meeting on the teleconference line, as the audio broadcast on our website experiences a 1 to 3 minute delay. When giving a public comment, please limit your remarks to 3 minutes. We ask that everyone who is not intending to make a public comment, please mute their line or minimize background noise. If there are technical difficulties when we are in the public comment portion of our meeting, we will do our best to read submitted comments into the record at appropriate times. Thank you for your patience and understanding.
Thank you, Ms. Taylor. With that, if you would please call our first agenda item.
Our first agenda item of the day will be item C1, Public Hearings, Taxpayers Bill of Rights Hearing. A public hearing to allow taxpayers to comment on items in the Taxpayers' Rights Advocate Annual Report or issues related to the agency's administration of its tax programs. Taxpayers can share their experiences with property tax problems they may be having, so the agency can help facilitate resolution. This matter will be presented by Ms. Thompson.
Good morning. Is
morning.
Ms. Thompson there? Oh, I see
Yes.
her on the screen now. Good morning.
Good morning, Chair Vasquez and honorable board members. I'm Lisa Thompson, the agency's Taxpayer Rights Advocate and Chief of the Taxpayer Rights Advocate Office. I'm pleased to be here today to conduct the annual Taxpayer Bill of Rights hearing to allow property taxpayers, as well as industry representatives, government agencies, and other parties the opportunity to provide comments before this elected board. The hearing is held in accordance with the Morgan Property Taxpayer Bill of Rights and the California Taxpayer Bill of Rights. Before we extend the opportunity to the public to provide their comment, I would like to share some information on the format and purpose of this hearing. and then discuss the most recent Taxpayer Rights Advocates Annual Report, which is fiscal year 1920. This can be accessed on our agency's website through the Taxpayer Rights Advocate pages, as well as by viewing the agenda notice for this board meeting. As to the format or the order of the speakers, we would like to extend the opportunity to speak to those that notified the Taxpayer Rights Advocate Office or the Board Proceedings Division of their interest to speak prior to the meeting. And then we will go to the speakers on the teleconference line that wish to provide comment. After each speaker, I would like to make some remarks on past work that the Taxpayer Rights Advocate Office may have had with them, or if that's applicable, or to provide some other comments if we have not yet had the opportunity to work with them. As to the purpose of the hearing, it is to give taxpayers, industry representative, assessors, and local agencies the opportunity to provide comments on the items or problems discussed in the annual report from the Taxpayer Rights Advocate Office for the purpose of correcting any problems identified in those reports, and also to provide comments on any other issues that they may be working with our office on, as well as on property taxes in general. Parties may also comment on programs administered by the State Board of Equalization, the quality of our agency services, property tax issues as well. Individuals may present their concerns regarding issues related to the administration of any of its tax programs, including state and local property taxes, the alcoholic beverage tax, or the tax on insurers. To publicize this Bill of Rights hearing, we issued letter to assessors 2021-23 on June 10th, 2021, which is distributed electronically to approximately 3,500 subscribers. We distributed posters and flyers to local agencies involved in property tax for posting in public areas. And similar to last year, we contacted the following 6 major organizations and asked if they could notify their membership about the opportunity to speak, as well as invited representatives from their organization to speak. And those organizations are the California Taxpayers Association, commonly known as CalTax, Howard Jarvis Taxpayers Association, Spidell Publishing, California Society of CPAs, California Society of Enrolled Agents, and California Chamber of Commerce. Additionally, we notified the California Alliance of Taxpayers Advocates and KPMG. Additionally, there was a news release, and the hearing was advertised on various social media platforms, Facebook, Instagram, Twitter, and LinkedIn. For the first time ever, we also had a public service announcement that was recorded, and that our agency worked with the media services of the California Department of Tax and Fee Administration on this, and we think they did an excellent job. The hearing was also noticed as part of the August board meeting. So this year we had a lot of exposure to it, and hopefully that will be a lot of viewers. Over the last few months, the Taxpayer Rights Advocate Office has had an increase in contacts. So apparently that our additional outreach is working well to get the word out that we're available to help taxpayers. Our agency's Taxpayer Bill of Rights hearing is held in accordance with certain statutory provisions. So to provide some framework, I'd like to provide those provisions. For property taxpayers, the Revenue and Taxation Code Section 5906D states that the board shall annually conduct a public hearing soliciting the input of assessors, other local agency representatives, and taxpayers to address the advocate's annual report pursuant to Section 5904 to identify a means to correct any problem identified in that report. And for the alcoholic beverage tax, Revenue and Taxation Code Section 32863 states that the board shall conduct a annual hearing before the full board to allow industry representatives and individual taxpayers to present the proposals on changes to the alcoholic beverage tax law to improve voluntary compliance and the relationship between taxpayers and government. The Taxpayer Rights Advocate annual report that is applicable to this hearing is fiscal year 1920, which was published in February of 2021. That report included discussion on problems or issues in the area of property taxes and contained examples on property tax cases illustrating how the Taxpayer Rights Advocate Office assists taxpayers. Additionally, that report includes our involvement in education to local taxpayers. We do this through the publication of information sheets that are written in simple, non-technical terms and are geared to assist taxpayers in understanding various property tax topics. Before we invite taxpayers to share their experiences or voice their concerns before this elected board, I would like to share some statistics on how many taxpayers we assisted in the last fiscal year, the fiscal year for that report, and also provide some information on how the Advocate's Office helps to resolve problems that taxpayers may have with the assessment or collection of property taxes. And so for fiscal year 1920, our office worked on approximately 250 cases, all in the area of property taxes. The majority of those taxpayers contacted our office through the web inquiry form that we have that is accessed through the Taxpayer Rights Advocate Office page or by phone. A significant number of cases were also forwarded to us from board members' offices after the taxpayer reached out to their offices seeking assistance. The majority of taxpayers that the Taxpayer Rights Advocate Office assisted were from District 1, Board Member Gaines's district, and District 2, Board Member Cohen's district. But the other two districts were represented as well. And the majority of cases pertain to valuation issues such as value reductions, change in ownership, new constructions, exclusions from reassessments, exemptions, assessment appeals, and general property taxation. The remaining cases were in the administrative category, which includes topics such as creating or mailing of tax bills, refunds, and penalties. This year, the annual report identified problems taxpayers experienced with property tax bill penalties, property being reassessed for a change in ownership, when the property owner passed away and a family member inherited it, and another problem with the transfer of a base year value from one home to another for a person over age 55. This year, the annual report identified these problems. So I'm just going to give a little bit of information about the types of cases. In one of the cases, a taxpayer received penalty for not paying the second installment of the property taxes on time. And we contacted the taxpayer tax collector's office to find out when the payment was made and the amount. We then explained to the taxpayer in non-technical terms the reason for the penalty and that the taxpayer could submit a penalty cancellation request to the tax collector's office. In another case, a taxpayer received several tax bills for supplemental assessment and that covered several years of escape assessments as well. When an assessor reassessed a property for a change in ownership due to the death of a taxpayer's parent that happened many years ago. The Taxpayer Rights Advocate Office coordinated with the assessor's office to obtain information on the change in ownership reporting and supplemental assessment noticing. We then explained to the taxpayer that even though the change in ownership occurred more than 3 years ago, the taxpayer could complete and submit the parent-child transfer claim form, and it would be considered timely as long as the taxpayer filed with the assessor within 6 months of the assessor's supplemental notice. After the claim was filed with the assessor's office, we then worked with them to expedite the claim processing, and the exclusion was granted with the reassessment reversed. In another case, when the assessor denied a base year value transfer request for a person age 55 and over, We help the taxpayer understand what documentation could be submitted to show that the house which was sold was in fact their principal residence, even though they had not claimed the homeowner's exemption on that. A large part of the Taxpayer Rights Advocate Office role is to help facilitate resolution of taxpayers' problems. And we do that by working with property tax agencies such as the assessor or tax collector to obtain information about the assessment of the taxpayer's property and the corresponding property taxes for that property and other charges that may be included on the tax bill. If the issue is with work performed by programs that are directly performed or administered by our agency, then we work with a particular section within the property tax department or other departments on resolving that. We review each taxpayer's situation on a case-by-case basis, conduct research and analysis pertaining to the case, contact local agency representatives, and review existing guidance on the case, and then help resolve the taxpayers' issues with that agency. We largely help taxpayers with problems that they have with the assessment or collection of property tax on their property. And oftentimes, a taxpayer just needs assistance in understanding what documentation needs to be provided to the assessor's office to arrive at a solution, or to receive some confirmation by a third party, us, the Taxpayer Rights Advocate Office, that they were treated fairly according to the law. In addition to helping taxpayers with specific problems that they are having with the assessment or collection of property taxes, we also help with larger issues that can bring about change. That can start with somebody contacting the Taxpayer Rights Advocate Office, or with somebody attending the Taxpayer Rights Advocate Office like today and bringing comments to the elected board. And if you look at the Advocate's 2019-20 annual report, it identifies one such project that resulted in many beneficial changes, and that is the Assessment Appeals Project. At a past Taxpayer Bill of Rights hearing, a taxpayer organization came to the hearing expressing concerns that taxpayers were having with the assessment appeals process. A project was then started by our property tax department with the project going through the interested parties process with participation from the taxpayer group that brought the issue forward, the California Alliance of Taxpayer Advocates, as well as the California Assessors Association and Clerks, California Clerks Association. And so in addition to property tax rule changes, that project resulted in revisions to guidance issued in our agency's assessment appeals manual, as well as a new form created that all 58 county assessors must use in making requests for information to taxpayers under Section 441D. That project was completed shortly after fiscal year 2019-20, the year of that report, and bringing issues forward with results just shows that coming to the Taxpayer Bill of Rights hearing and providing comment to provide comment as well as voicing their concerns can bring about changes, and it's very important. So for today's hearing, we were notified that there are 8 speakers. That was prior to the hearing that contacted the Board Proceedings Division through public comment or Taxpayer Rights Advocate Office. I'll just go and list them out first, and then before introducing them. For today's hearing, we first have Honorable Ernie Dronenberg, San Diego County Assessor and President of the California Assessors Association, who indicated he would be calling in to provide comment. Mr. David Klein, on behalf of the California Taxpayers Association, CalTax, he also indicated he would be calling in. Mr. Bart Norman, a taxpayer from Valley County, indicated he would be calling in. Mr. Dil Kazaz submitted comments in writing to the Board Proceedings Division through our public comment form. And Ms. Jamie Karodi submitted comments in writing to the Board Proceedings Division through the public comment form. TR John submitted comments in writing to the Board Proceedings Division through the public comment form. Ms. B. Stolzer, on behalf of a nonprofit organization, submitted comments in writing, also through the public comment form. And lastly, Corrine submitted comments in writing through the public comment form to board proceedings this morning. And that concludes my opening remarks. Unless there are any questions from the board members or comments, we can invite taxpayers that provided comment to us previously to start. And then we would invite people from the teleconference line. So after each speaker provides their comments, then I would like to provide comments, some remarks to speak to any action that we may have had with those taxpayers or future action that could be taken. So we would like to start with Mr. Ernest Ronenberg, San Diego County Assessor and President of the California Assessors Association, and I'll send it back to the board proceedings clerk to call that. Thank you very
Vice Chair
much.
Schaefer, before you go to the, Mr.
Just,
Dronenberg,
there's a couple hands up I see
Oh,
before we
okay.
get
Ms. Cohen
started.
and I both have
Yeah.
comments.
I see Member Cohen and Vice Chair Schaefer.
I
Member
defer.
Cohen, go ahead.
Thank you. Thank you very much. Thank you, Ms. Thompson. So I see from the annual report that the TRA office handled approximately 250 cases, and that the majority of these cases were in the valuation category. My question is whether you have any recommendations for additional taxpayer education, additional outreach to assist taxpayers in understanding the valuation issues.
So we have currently we have taxpayer information sheets on base or value transfers for seniors, as well as exclusions, parent-child, grandparent-child, as all base or value transfers for seniors, as well as disabled persons. Those were impacted, as you know, by Proposition 19. So we will be revising those information sheets, as well as adding another one for disaster relief. So as we do those, we will do that. But we do have quite a bit of contact from taxpayers on base or value transfers or exclusions under, family transfers, whether that be from, current law or under the, current law, Prop 19, or previous law. So those are key areas, and those impact, change in ownership. And as far as that, it's change in ownership unless exclusions applies. But we do take note of the areas that we get recurring concerns about, and then we try to address those. Thank you for that.
So is that a yes or a no, Ms. Thompson? That was a lot. Just make it simple for me. Are there any, can you hear me? Are there any opportunities for education outreach to assist taxpayers?
Yes, so we will, yes, on our information sheets, and we will do that. Thank you.
Okay. So also noted from the annual report that the San Francisco's Assessor's Office conducted a series of taxpayer outreach and education events. These were events included in 2020, the first welfare exemption workshop to help local nonprofits save on property taxes. It was actually attended by 130 participants, and the annual signature, the Family Wealth Forum, attended virtually by over 250 viewers. The report shows that over 90 questions from taxpayers were answered by the panel of experts. And so my question for you is whether, or what are your thoughts on extending these outreach education events to other counties? I think Fong Law might do something very similar in Alameda County, but I can't say with any certainty. I do know San Francisco because that is my home county. But I'm wondering if there's just a way that we can extend this either by individual counties or by the Board of Equalization conducting a statewide or regional taxpayer outreach education events. I also want to note that the San Mateo County Assessor's Office has implemented a DocuSign solution to make it possible for users to fill out forms and to sign and submit online from any device, making sure that it's available 24/7. And then my final question is whether there are any efforts by the Board of Equalization to work with other county assessors' offices to implement other technology, electronic solutions to eliminate the need for wet signatures.
So as to your first question, that individual counties, assessors offices have put on workshop. Not San Francisco is one of them. In our improvement section within our Taxpayer Rights Advocate annual report, we ask for input from assessors and they submit that, and so we highlight them. But there have been assessors that partner with their board members to put on these workshops, and it's definitely a way to get information out to the taxpayer. So, so that is something, a viable alternative to look at. As to, efforts to work with assessors on electronically, I can't speak to that. The property tax department would be, more appropriate. But yes, I'm aware of, certain efforts that are being made. I mean, electronically, there's changes that are in place in the works now just for tracking the base year value transfers and inter-family transfers because of Prop 19. So
Thank you.
thank you.
Vice Chair Schaefer, and then I have Ms. Stowers after that.
Hello.
I think you're muted. Vice Chair, you're muted.
Yes, thank you. Ms. Thompson, you had a very impressive list of taxpayers who wanted to offer comments, and you identify them all by name. That means we don't have any anonymous commentators, is that right?
We do not,
Oh, hooray, thank you.
as of now. Yes.
Thank you. Ms. Stowers. You're muted.
Thank you.
There we go.
Let's see. Thank you, Ms. Thompson, for your opening remarks. Very detailed. I appreciate it. And I also like that you made it clear that this hearing is also for industry and individuals who do business with the BOE and the county assessors. I have a question, and then I want to kind of follow up on what Ms. Cohen was saying when she was talking about education, outreach, and workshops. I think I heard you say, yes, updating the fact sheet is definitely on your list. But I would like, and I don't know what our resources are, but I would like to see if our office, the Taxpayer Rights Advocate, could take the lead on some of these common problems and workshops. Develop the workshops, especially if we're doing it virtually. Develop the workshops and then go out to each county to see if they're interested in the workshop and partnering together to hold them virtually in their county or sending out invitations to those people within their county. I think that would be more effective and efficient. And
Well,
I'm not, go ahead.
oh, no, go ahead, finish.
And then my other comment or question is just, I'm just kind of curious. I know that we have a statutory mandate for a Taxpayer Rights Advocate office in the annual report that you just went over. Do the assessors have a similar local mandate? Or are they just providing advocate services through, or most providing advocate services through their offices?
Okay, so for one, for the TRA office to kind of work with different assessors to try to give workshops, I'm happy to discuss that with our executive director and see if that's something that we're able to do, especially now that we're more in a virtual environment to do. So that would minimize travel and budgetary constraints. So we can certainly look on that and to see if there are if there's information that we could develop that could be given by different assessors' office, should they, choose to do that. And some of the provisions of Proposition 19, might be a way to do that because that is new and it's important for taxpayers. So having a standardized, means to provide that would be a good idea. And so I can also discuss that or bring that up at the next Assessors Association conference to see if they would be supportive of the Taxpayer Rights Advocate Office, assisting them in that endeavor to train their local taxpayers. So that can be done. So for the second one, as far as the mandate to have a Taxpayer Rights Advocate Office, that is actually at the state level. It's for different taxing agencies at the state. But I think assessors, kind of as a matter of practice, their office is, provide customer service, and that's kind of a lot of what it is, and advocacy as well. So, but there isn't a mandate that they include one. I am aware that there are counties in the state that have either had, kind of a designated or a specific person as their own internal taxpayer rights advocate or similar ombudsman or something. So, they've had that, but that's just up to the discretion of that. And I don't know if that's something that like smaller counties would be able to designate, but as a matter of practice, I think that all assessors are very supportive and their staffs of customer service and providing, the services to them.
Thank you, Ms. Thompson.
Thank you.
Thank you. Those are very good comments. Ms. Thompson, I just have a couple of quick follow-ups. And I know we're going to have, when you mentioned several of the folks that are going to be speaking to us that'll be calling in, I'm going to let them chime in. But the one, I guess, when we do get our president on board, Ms. Dronenberg, that might be a good question to ask them to see if, in fact, they're willing to partner with us for this. Now that we can do things via Zoom or virtually, I think it's a little bit easier probably to do them, as opposed, like you mentioned, to have folks traveling up and down the state to do these. But in your opening remarks, you cited a couple, I guess, examples of cases that you're working on or if you've done with some of our taxpayers. And you kind of touched on one that I had a question about because I happened to run across a couple of folks over the weekend at a reception who, due to COVID now, I didn't realize that, as we're hearing about so many people passing away, now they're willing in some cases willing, in some cases they didn't even have a will. So, their homes or their assets are now being distributed by their kids, or in some cases their grandchildren. And a question came up because this one was actually set up in a trust. And I don't, you kind of touched on it. What happens? I know upon transfer of a property, it gets reassessed. But if it's sitting in a trust, does it get reassessed after somebody passes away, or only does it sit there until it actually transfers out of the trust?
For property and held in trust, the date of change in ownership is what controls, because that is the person's trust. And so in the case of like families where they're inheriting, that's why it's so important, is that even though it's held in a trust, that the change in ownership statement be filed timely following the death of that. Really, it's the property owner, because they're the beneficiary of that trust. And they do need to advise the assessor's office through the change in ownership statement on a change in ownership. It's a death, COS. Let's see, 502D, I believe. And so they do have to file that within that time period. And the same thing then is, so it's not just, within the date of transfer. So it's important that they keep that in mind. And the reassessment would occur as of that date of death. So that's the importance of providing information to the assessor's office in order for them to get that parent-child transfer in place as quickly as possible. But again, we're looking at Proposition 19 if you have a death that occurs, currently after February 15th. So, so there are still different rules in place depending when the decedent passed away. So we have two forms, two different types of forms now for that are prescribed depending on the date of change in ownership. So
just to be clear, so you're saying if it's in a trust, that in itself, even with somebody passing, doesn't constitute a transfer of ownership, or it does
No,
upon death?
it does
does.
as the date of death, yes,
So it does get reassessed at that point?
unless an exclusion applies, yes.
And what would be the exclusion?
Well, like if you have a family transfer, say a parent-child transfer, grandparent-child transfer.
Oh, if they transfer it to a child.
If
or
that
a
case,
grandchild.
but other than that, if it doesn't, so let's say the, decedent's will or trust, whatever document that they have says that, that it passes to their nephew. There's not an exclusion for that. So it's reassessed.
Oh, well, you bring up a good point, because, for example, in this one, they happen to have, five, he passed away and he had five children, right? But he
Yeah.
did, in the trust, it was written that upon his death, it would be transferred to one of them. So when it's transferred to that one individual, that would also constitute a transfer of ownership, I'm assuming, right?
Well, so I mean, I'm not a legal expert, but yes, it would be
Okay.
transferred. But if it's designated, so if it's designated in the will, or in the trust, that one of the five children receives that asset, is distributed that house, then I mean, it depends on the timing of the death. So let's say if the person died, if the father or mother died in 2020, that's going to fall under the old rules. So actually, if that house is distributed in the will to one child, is designated, they get X property, then they can file the parent-child transfer claim form and get excluded. Doesn't matter if it's going to be their primary residence or if it's a rental property, because they passed away in 2020 before this Proposition 19 was effective, then that would be eligible for exclusion and it wouldn't be subject to reassessment. Be a different situation depending on if they died, after the effective date of Proposition 19. If they died after the date of Proposition 19, then they would not be able to qualify for an exclusion, say if it's a rental property. But if it was a principal residence of the parent who died and the sibling who was designated to have that home in the trust or will moved into it and filed for the homeowner's exemption within a year, then it's going to be eligible for exclusion. So,
And let me just add one more wrinkle to this. What if on the trust, it actually specifies that a grandchild is allowed to stay in the home, the principal home of the deceased for 10 years?
Yeah, I mean, would be happy to talk with legal and try to provide this to you differently. I mean, I think the scenarios would be different because, I mean, it depends, first of all, if the grandchild's parent is deceased themselves, because otherwise the grandparent child transfer doesn't count. So there's a lot of variables. So I think it depends on the case by case basis and the specifics of the situation. So I don't want to make a broad statement that don't do that. So.
And my last question, because I was actually on a talk show yesterday and I made a statement, but I kind of qualified it because I didn't want to put out wrong information. So I told them to listen in today. So hopefully folks might be listening today from that talk show. And a question came up and I think we've had this conversation before, but I want to make sure I'm giving out the right information. So on a transfer now, let's say, now this is a living person, right? A person who's retired and decides to sell their home and wants to either scale down or scale up, move into another area, but doesn't want to, but wants to transfer the value, the property value, or I guess the assessed value they have on their home. I know they're allowed to take it with them, right? For example, under Prop 19, before it was a little bit, it wasn't a guarantee, but now under Prop 19, let's say if somebody lives in San Bernardino and decides to move into Orange County in let's say a smaller home, but obviously probably worth more, could that individual take, whatever taxes he's paying if he's over 55 from San Bernardino into Orange County?
So it depends when one of the events take place. I'm not certain if Orange County was, so before Proposition 19, in order to move the factored base year value for a person over 55 to another county, the law required that an ordinance be passed by that county board of supervisors where the person's moving to. So there were only 10, I believe 10 counties in the state that accepted that. And I'm sorry, I don't know off of the top of my head with that, or if Orange County was one of them. Our website actually lists those counties and discusses that under frequently asked questions for Proposition 90 and 110. So you can, or 60, 90, and 110. If you look at that information, that will list those counties. But currently, with the passage of Proposition 19, that expanded it. So that basically allows a senior to take their factored base year value to, from one county to any of the 58 counties in the state. So, so under the assumption that that it's after the effective date of Proposition 19, April 1st, 2021, for the base year value transfers for seniors, that person could transfer their factored base year value of their house from San Bernardino to Orange County. And what would happen is, so that factored base year value would transfer. But if the house, like you said, the house in Orange County is probably a little more expensive than San Bernardino. So if the market value of the Orange County replacement property compared to the original property that was sold in San Bernardino is more, the excess of that market value will be actually added to the factored base year value that is transferred from that San Bernardino home. So basically the difference is taxed at market value and added to it. So that's a benefit really for the California taxpayers, because before Proposition 19, you couldn't. So basically, if the market value of that replacement house was more than the market value of the original, you lost out. You couldn't actually transfer your factored base year value because that was one of the restrictions. It had to be, the replacement had to be equal to or lesser than the market value.
So for example, if the San Bernardino home is they bought it for 300,000 and they buy some for 1.3 in Orange County, 300 would be deducted, but they would be assessed only on the million, not the 1.3. Is that it?
It's the factored base year value. So it doesn't really matter what, it's not exactly what they bought it for in San Bernardino, because
what it's assessed by
10
the
years
assessor.
ago. So you have to factor it forward. So you can, you factor it forward, based on the CPI. So the maximum of 2% increase each year. So it's the factored base year that would transfer. Hopefully that answers your question. Thanks.
So it actually could be a lot higher, right?
Yeah, more than three.
That they're transferring.
It definitely would be more than 300,000 if they bought it for 300,000, say 10 years ago, because the factored base year value today is going to be higher.
Gotcha. Okay. I see another. Was that an old hand or is that a new hand? No, it's an old hand. And I saw member Cohen. Oh, Vice Chair Schaefer, that is a new hand.
Yes,
Go ahead.
yes. Ms. Thompson, I had just a very general question. I noticed in the annual report that our office generally assists taxpayers who have been unable to resolve a matter through normal channels. Do we enforce that, that they have actually tried some normal channel before they come to us, or do they come to us as their first recourse?
We don't enforce that. It's yeah, I mean, if they contact us, then we assist them. So we don't, require that they had reached out, to the assessor's office to try to resolve it ahead of time. So
yeah, that's
sometimes
good.
they do. Yeah, sometimes they do, and sometimes they don't. But it just depends on the situation. I'd say oftentimes they, try to reach out to the assessor's office, but certainly not always. We're happy to help any taxpayer that,
I
approaches.
appreciate that. Thank you.
And I think I have a new hand. Is that member Cohen? Is that your hand up? Member Cohen, is she? That might be an old hand then. Okay. with that, oh, Ms. Stowers that's a new hand, right? Ms. Stowers, go ahead.
I am a new hand, and I would like to ask a question, but I am sensitive to if we have the people on our public lines waiting to speak.
Yes.
So
We can continue the conversation after the public speaks.
okay.
Why don't we do that? Because I know there's several people waiting. Ms. Taylor, if you could locate, I guess, we have written comments. Do you want to start with those first, or those people on the line, Ms. Taylor?
I believe the plan was to start with our speakers, so I can call and see if
Yes.
is the Honorable Ernest Dronenberg on the line. All right, AT&T operator, could you please let us know if Mr. Dronenberg is on the line?
I am not seeing him on. If he's on but did not dial in as a speaker, he can press *0 for an operator, *0 if you're on the main line. Okay, and it looks like he may be on the main line. One moment. And they're just gathering his line. One moment. Okay, and Ernest, your line is open. Okay, one moment. They're still with him. One moment. Sir, your line is open. Are you able to hear us?
Yes.
Okay, your line is open. You're able to speak.
Good morning, board members. Can you hear me?
Yes, I can hear you. Go ahead. Welcome.
All right. Well, it's again a pleasure for me to join you today. This topic of the Taxpayers' Bill of Rights is near and dear to me since I was the proponent of this when it very first started, and the board was real supportive of it. The Harris-Cass bill was actually written by my office, and then when we wanted to complete it, it was sales tax and then income tax, and then finally we got Senator Morgan to do the property tax piece. But so way back then, it was a part of my program, and I'm glad that it's still functioning. And I wanted to compliment Ms. Thompson. It is working well, as the assessors have all mentioned to me. They are very happy with the support that the board is giving them with the Taxpayers' Bill of Rights hearings, as well as with the office during the year. I noted that there are several questions. I don't want to take all the time, but there are several questions that you asked that I might be able to answer. I have a taxpayer's advocate position in my office, and I know that Orange County has a taxpayer's advocate in their office. I don't know of any others. That's sort of like I can neither confirm or deny that there are others have them, but I haven't heard of any others. Jeff in LA might have one, but I haven't heard of any others other than San Diego and Orange County. The mention of electronic signatures in 1993, we became the first office in San Diego to do an electronic signatures for a form, and that was with a change in address form. And today we have 10 other forms that are, and some of them requiring 2 signatures even, done electronically. So this is something that I've been a champion of and trying to push other assessors to do. It is costly at first, but the end saves the office money because it costs quite a bit to program a form electronically, but once you've got it in place, then it pays back quickly, and I think it is a good idea. Prop 19, all the hearings that were going on, I think Board Member Cohen was talking about that. We had over 20 hearings in my office. This was a real information soaking up kind of program. Everybody wanted to know about it, so we just had to advertise that we were going to do it, and then I think we had over 500 names, people on the line. I know San Francisco had a huge one when they first started. I know Board Member Cohen's office was a real part of that, and a former assessor from San Francisco was a part of it. But as you know, right now we're doing electronic classes. So electronics is a key word as to how we can use it in greater and greater extent. Will only pay dividends for us in our limited resource situations. The question about change of ownership that Tony, Chairman Vasquez asked, I think was adequately answered by Ms. Thompson. But I'm sure the best resource for some technical pieces of which are still not ironed out because the legislation still hasn't passed for Prop 19. But we're doing the best, and I'd say your office is doing very, very well with the unsecured language. We just have to guess what the outcome will be, but hopefully by the end of the session, the bill will pass and we can give complete, with faith, the guidance for somebody that wants to do change of ownership. I mean, with transfer of base or generation transfer. Both of those situations will be finished when the session ends, hopefully. Other than that, again, compliments to the staff and their program. I think it's very well being used, and they're doing a good job at trying to get out and get information to people now.
Thank you.
That concludes my report.
Just a quick comment. You know, it was brought up, I don't know if you were listening in on the part where there was a possible request here that we might want to look at involving the assessors in different counties throughout the state and now that we can do these things virtually, working with our staff to try to get out the word or have these hearings in respective counties. And I think it'd be pretty effective if we did a partnership with many of the big assessors throughout the state of California. I don't know if there's an interest.
Yes, I
in that.
did hear that. I did hear that, Tony, and I think good idea.
Okay. Thank you. With that, Ms. Taylor, do we have the next? Oh, wait, Ms. Thompson, did you have some comments?
I do, thank you.
Yes, go
So we appreciate Mr. Dronenberg's comments. As part of assisting taxpayers, our office works closely with management and staff in the 58 county assessors' offices to obtain information on taxpayers' properties and to coordinate with them to resolve taxpayers' problems or issues. So we appreciate their continued cooperation. Our office is also pleased to assist assessors in their efforts to educate taxpayers through the issuance of information sheets that provide topics, information on exclusion and exemption topics that provide simple and easy to understand information that may result in property tax savings to them. And we're happy to explore providing information and education electronically with assessors in partnership. And we'll discuss that further later. That concludes my remarks. Thank you.
Thank you. I see a hand from Member Cohen.
Yes, thank you, Mr. Chair. So what I'd like to suggest is that we identify the top 5 issues and develop taxpayer training / presentation modules that we may roll out virtually across the entire state. And again, this is in partnership with our local assessors and our offices. to help facilitate this ongoing conversation, and all in all, be proactive in our outreach and education for on behalf of taxpayers. So I'd like to recommend that we identify the top 5 issues and develop taxpayer training and/or modules in a presentation. That's it. Thank you, Mr. Chair.
So we're thinking of also working with the assessors. Do we want to hold until maybe after we hear from all the public to see which might be I guess what would surface as the top 5?
You know, I'm fine with doing that. It's a process thing. I just wanted to go on the record based on what I'm hearing from the presentation, based on my own personal experience. I thought that it would be just a good suggestion. We could always have the executive director weigh in and hear her thoughts as well. So I leave it to you in terms of process.
Thank you. Seeing no other hands or comments, Ms. Taylor, who else do we have on the line? Oh,
Mr. Chairman?
yes, go ahead, Ms. Dornberg. I can't see you on the screen here.
I think that's an excellent idea. We have our annual meeting coming up in just a month and a half. Maybe we could survey the assessors and report back at that meeting what our top 5. I could get our secretary to canvass all the assessors and get their picks of the top 5, and then provide that to you at the annual meeting, and then you can combine that with what your top 5 is, and maybe we have some consensus. I think that's a real good idea to start with.
That works with me. All right. Why don't we just hold that, and then let's see who else we have on the line, Ms. Taylor.
Thank you. AT&T moderator, could you please see if Mr. David Klein is available to speak on behalf of the California Taxpayers Association?
Thank you. His line is open.
Good morning, Chairman Vasquez and honorable board members. Thank you for providing this opportunity to testify, and thank you to our prior speaker for being instrumental in the legislation that created the Taxpayers Bill of Rights hearings. I am David Klein, Vice President of Communications and Research for the California Taxpayers Association. We are also known as CalTax, the state's largest and oldest association representing taxpayers. Sometimes we appear at these hearings to voice concerns, airing of grievances and such, but today we actually just want to praise the board members and the staff for ensuring that despite the problems caused by the pandemic, the board has really continued to provide the guidance and statistical updates and assessment practices surveys and other vital services that are so important to California. CalTax and other groups use the BOE reports and statistics in a variety of ways to keep our members and the public informed. And so we appreciate the staff's hard work to keep the information flowing during a very, very challenging time for all of us. And we also would like to reiterate our thanks to the board for taking the lead on the issue of providing the option for assessment appeals boards to conduct their hearings remotely. I know this issue is on your agenda for tomorrow's meeting and will be discussed in detail then. So I won't really go into a lot now, but we do look forward to that full discussion and getting the perspectives from the assessors, from the assessment appeals board members, other taxpayers advocates, BOE staff, and property owners, and just everyone involved in the system. CalTax continues to believe that this is a situation in which the pandemic has given us lemons, but we could really turn them into lemonade by using the remote AAB hearings, not just as a short-term solution during the pandemic, but as a long-term option to give taxpayers more convenience and to help assessment appeals boards avoid some of the backlog they've experienced with the in-person hearings. Obviously, the due process rights of taxpayers must be protected, and remote hearings should be an option for taxpayers, not a mandate, since some taxpayers require in-person hearing, whether it's because of technological challenges or because they just need to be in person to effectively present their case. We did see the January 13th letter to assessors from the BOE that described the right of taxpayers to have in-person hearings or remote hearings. So we don't anticipate that this will be a point of contention, but we just wanted to raise the issue since it is so important to taxpayers. So we appreciate the BOE's continuing work on this issue. We appreciate the engagement with taxpayers and their advocates to make sure the rights are protected. And we really do appreciate this opportunity to testify. And thank you again for all the hard work in the pandemic year and going forward.
Thank you. Thank you for your comments. Ms. Taylor, do we have anybody else on the line?
Do you mind if I provide a little bit of
Oh, I'm
remarks?
sorry, Ms. Thompson, I keep forgetting. Yeah, go ahead.
So we appreciate Mr. Klein's comments. The California Taxpayers Association is a respected voice for taxpayers, and they have a large membership, including tax professionals working at large range of businesses in California. We thank them for their input and for joining us today, and look forward to working with them in the future on any issues that they may have. Thank you.
Thank you. Ms. Taylor, if we can go on to our next speaker.
Certainly. AT&T operator, is Mr. Bart Norman available?
Thank you. His line is open.
Hello. Can you hear me or?
Yes, we can hear you. Go ahead.
Hello?
Yes.
Okay. I'll make this as quick as possible. I had an issue with a parent-to-child transfer at our local county assessor's office. We had a trust that property was held in. Our local county assessor, we messed up. The attorney that we hired did transfer the property to me and my brother right out of my dad's trust. From there, it was reassessed at a 50% because it went to me and my brother instead of just me directly. We did do rescission deeds, and the local assessor would not accept the rescission deeds. This was maybe in 2018 before Prop 19 was in effect, so Prop 13 was in effect at the time, where parent-to-child transfer is exempt. Our local assessor's office gave no guidance, didn't ask. They just said they would not accept the paperwork at all. We asked, why wouldn't the rescission deeds be accepted? They said they're going to accept them the way they originally presented. We were not going to accept the rescission deeds. And everything that I ever read from the Board of Equalization on the website said that county assessors should accept rescission deeds. Well, every time you would talk to them, they would actually say that we cannot give legal advice. So they said that we needed a court order in order for the rescission deeds to be accepted. So 3 years later, we're still fighting this out. We filed an appeal, hired an attorney to draw up the paperwork for the appeal, which cost $2,500. During the meantime, I actually contacted, I want to say, Ted Gaines' office, and he referred me to the Taxpayer Right Advocate office, where I was in contact with Lisa Thompson. And once the Taxpayers Rights Advocate's office got involved, this was resolved in 3 weeks. There were certain things that they wanted, I guess our assessors wanted from us, that the trust was not closed. A few other things that we presented, gave them to Lisa Thompson, and she sent them over. Once she was involved, this issue was resolved within 3 weeks, and it took me 3 years and countless amount of hours trying to get them to accept the rescission deeds. Everyone makes mistakes, and I can't imagine living in a world where you can't fix those mistakes. And we made a mistake. We corrected it. It should have been accepted by our assessor's office, and it wasn't. And I don't know if every assessor's office is like this. And apparently in San Diego and Orange County, they have an advocate there. If we had one here in San Joaquin County, maybe this issue would have been resolved a lot quicker. But they're not giving guidance at the county. They're not telling you anything. They're just saying, we are not accepting your paperwork. And thank God that I was in touch with Lisa Thompson. This was a nightmare. When she was involved, it went as smooth as anything I've ever seen go. And I just wanted to thank her and thank the board and thank whoever set this program up, that this issue was resolved. I don't know how many people would have went through this process and given up. This took over 3 years. When she was involved, it took 3 weeks. So thank you, Lisa. Thank you, board. Thank everyone who has anything to do with setting something like this up for the normal person that doesn't have to hire attorneys to do everything. And even if you do, sometimes they do it wrong. And I want to thank Lisa and the board for, having this program there for people. The problem is no one knows about it. It took me 3 years to find out, and so upset that you just had to call everyone you could at that point to find out about the program. So I could answer any questions if you had any, but we're in San Joaquin County, and pretty much what was presented to us was we are not attorneys. We cannot give legal advice. We will not accept your rescission deeds when everything I read said that they should have accepted them. So that's my experience with my assessor's office and my experience with the advocate, Lisa Thompson. And thank you again, Lisa.
Thank you, and kudos to Ms. Thompson. I see a hand up
No,
from Edward
a
Gaines.
lifesaver, a lifesaver. Thank you so much. And thank you, Mr. Gaines, for referring me. It was a lady in your office, and thank you so much. It wasn't until I called your office and was set up with the advocate that we got this issue resolved, and it was resolved very, very quick. I was actually shocked.
Wonderful. Yeah,
It's
if I
great to
could
hear
say-
good news. Usually we hear all the complaints. Well, go ahead,
Yeah.
Member
Yeah.
Gaines. Go ahead.
Yeah, thank you so much for relating that to the board and publicly. We really appreciate that. And we have cases that come before us, and sometimes they're in favor of the taxpayer. I think we'd hope that they all were, but there's not always justification. And so I want to thank Lisa for going through the process and realizing that there was corrective action that could be taken to resolve your issue. And I think you highlighted some of the points that we as board members have been trying to make too, and that is, how do we get the word out so that our constituents are aware of the fact that we do have a taxpayer rights advocate that can help them in cases? So I know that we've bolstered our outreach, and we've got opportunities to, I hope, to get the word out in a bigger way, so that our constituents are aware that they have these opportunities to have someone take a second look. And sometimes, they were done in the right fashion. But it's nice to just have that second opinion, because when they're not done in the right fashion, we want to make sure that people are dealt with in a fair way. So thank you so much.
Yeah, thank you. It sounds like actually San Diego County and Orange County has an advocate in their office. Now, I don't know the expense of that, and I'm sure it would be quite expensive. However, if the assessor's office has an issue like this, they should simply give the number. If they can't help someone, they should give them your number. I literally had to find this out myself after years of just reading everything about it and actually calling and complaining to your office, Mr. Gaines. I mean, it's so frustrating. And when you guys got involved, it was resolved so quick. It was like, wow, this could have been resolved years ago. But I know that if I was an assessor, I'd probably want as much money from everyone as much as I could. But they should simply give, if they can't help and think that if they're not going to give legal advice or ask people or tell people what paperwork is needed, they should simply give the advocate's number out. And that way they could call and have a second opinion and go from there. But they're not doing that at all. If I was an assessor, I probably wouldn't either, but that's probably the right thing to do, is to give that number out if they possibly could.
Sure.
That's my
It's nice to see it. Nice to see it work right. Just like Chair Vasquez was saying, that there is this, I mean, that's why we exist. That's why the Board of Equalization exists, is we want to make sure that people from county to county are treated in the same fashion.
Well, we're not. So if they have an advocate in San Diego County, Orange County, and they're having a tremendous service by having that advocate, the rest of the state doesn't, I don't believe that's fair. But that's just my opinion, I guess.
Well, we'll have to take a deeper look at that. I think that Member Cohen has some ideas on how we can expand that, and would like to, the board would like to work
Well,
on that. So
I just want to thank you guys for even setting up this program, and thank you, Mr. Gaines, for getting me in contact with Lisa. And thank you, Lisa. This has been a great experience with you guys. Absolutely great. With the assessor, it was the worst experience of my life. I hope no one ever has to go through that again. So thank you again. And if that's it, I'd like to spend quite a while on the phone.
yeah, thank you very much. We appreciate it.
Thank you.
Does
I see
anyone
a
else have
hand up for Ms.
questions?
Thompson.
Or sure.
You're muted though. Ms. Thompson, you're muted.
Sorry, thank you.
Okay.
Thank you for sharing those thoughts with us, Mr. Norman, and for your kind words. We really appreciate it. So we were able to work with Mr. Norman and the assessor's office on providing the information that was needed in order to reverse the reassessment as of the recording of that rescission deed and to restore the factored base year value. This was a complicated case. It was not straightforward. There was a lot of research involved with the trust situation and rescission deeds. So fortunately, our office was able to take advantage of resources that our agency publishes in these areas, and conduct the necessary research to explain to the county assessor's office how it shouldn't be reassessed, and then also to talk with the taxpayer about information that he or his attorney could provide on the trust, and to indicate it was not had not been dissolved at the point of the rescission deeds being recorded. So recently we confirmed with the assessor's office that the 2021 lien date assessment reflects that reduced factored base year value to before the property was reassessed in part for the transfers amongst the siblings. And we also confirmed with Mr. Norman that he received a refund of taxes paid. So that ended up well for him. And hopefully, there's other taxpayers that are aware of our services. We'll certainly just mention that availability and talk with Mr. Dronenberg, maybe at the next assessors conference. He can, let their association and all of the assessors, know that they're welcome to provide our phone number or website to their constituents if they have problems, and maybe disseminate that out to their staff. So we know that the assessors are aware of them, but maybe they just need to remind some of their staff, newly hired staff, that we are available. So thank you so much.
Thank you. With that, Ms. Taylor, who else do we have on the line?
All right, next we're going to read a series of written comments. Myself and Ms. Renati will take turns. Our first comment is from Mr. Dil Kazaz. The Chief Counsel of the BOE, in his memorandum of January 8th, 2021 to the board, analyzed and legally reasoned the meaning of the Proposition 19, including, more importantly, the time factor of applicability. He said in the forefront of his analysis that neither the sale or purchase of a replacement residence need be after April 1, 2021. Now today you are adopting a form of that proposition that is contrary to your chief counsel. Why? How can you ignore the contribution of your chief counsel? Are you aware that your actions will deprive many of the benefit of what we passed Proposition 19 for? Is it filling the coffers? Our votes don't matter and laws don't either. Someday your votes will be ignored like mine is today. I hope you will not disappoint us. Ms. Renati? Oh, Lisa, are you going to comment?
Yes, I am. Thank you. So we appreciate the Mr. Kazaz's comments. He expresses concerns about information that was disseminated about Proposition 19. We are happy to reach out to him to provide him with information to help him understand what was approved by the voters by Proposition 19 in November of 2020, as well as how the property tax rule fits within Proposition 19 and the form developed by our board. as well as how the Proposition 19 effective dates work. So that concludes my remarks.
Thank you. Who's next, Ms. Taylor?
The next comment is from Jamie Carodi. She states, I represent Tongva Land Preservation Corporation, a California 501c3 in Santa Monica. Over the past 2 years, we have been working on receiving a welfare exemption certificate. The process from the perspective of an average taxpayer is quite cumbersome. Fortunately, we have been guided by the BOE Taxpayers' Rights Advocate, Lisa Thompson. Ms. Thompson has been instrumental in helping us navigate an often confusing set of steps. Thanks to Ms. Thompson, we are readying the final stage of receiving a welfare exemption from the Los Angeles County Assessor. The critical role of the BOE Taxpayers' Rights Advocate in good, efficient government, and Ms. Thompson in particular, cannot be overstated. That concludes the comment from Ms. Carodi.
Thank you. Ms. Thompson, I see your hand up.
Yes, I do. Thank you. So we appreciate Ms. Carodi's comments and her kind words. Earlier this year, we assisted her in her organization obtaining an organizational clearance certificate from our agency, and then working with the county assessor's office for them to expedite the processing of their welfare exemption claim that was filed. So we're currently working with them to do that and to grant exemption for prior years in order for the auditor's office to refund the taxes, to calculate the refund with the tax collector refunding. So we're hoping that that's done soon. Their property actually was purchased out of a tax sale from the tax collector's office, and dedicating it to property under a natural state, qualifying under the welfare exemption under the provisions of Revenue and Taxation Code Section 214.02. So we were happy to help her navigate the process of the administration of the welfare exemption and coordinate with different agencies. We look forward to continuing our conversation and communication with the assessor's office in order to get this nonprofit organization granted the exemption. That concludes my comments. Thank you.
Thank you. Ms. Taylor, do we have
Yes.
anybody else on? Oh, we have
We do.
another.
Yes, we have another written comment. This comment is from T.R. Johns. Hello, I heard most of an interview on KVCR with Chairman Antonio Vasquez regarding issues to be discussed in the board sessions this week and seeking input from the public. I want to pass along the following comments and a suggestion for the Board of Equalization to consider. I'd appreciate having this brought up during your session on Tuesday or Wednesday, and I'd welcome any response from Mr. Vasquez or others regarding what I'm presenting here. I realize that the Board of Equalization is not a legislative body, but I understand that the board could raise the issue of importance and encourage the governor and the legislature to create legislation to address a real need of property owners. I believe county tax collectors are given some statewide rules or guidelines regarding how they handle annual property tax increases in the counties. I suggest that those rules be expanded to include additional factors beyond current assessed property values when setting or annually increasing property tax on individual properties within their jurisdiction. In particular, I think that a property owner's annual income should be considered along with issues like age range and other unique factors that may affect a property owner's ability to pay for property tax. The goal would be to reduce the tax burden on those who are retired, on fixed income, or have low income while trying to hold on to their homes. This can be restricted to those with a single home or property and one in which they reside, and can allow for the county to do a reassessment of the property tax should that person receiving a special allowance sell the property. Having tax increases only consider current assessed property value is unfair. It fails to take into account other factors that involve ability to pay due to restricted income or assets. That's why I believe that there should be options for property owners to seek some relief in the form of discounted tax assessment or similar compensation. This special allowance would be calculated using certain strict guidelines regarding property owners' annual income, age, and other factors that might create a burden on the ability to sustain annual property tax increases. I recommend a formula or method of calculation be created to give homeowners a chance to seek special allowance to keep property taxes affordable. I realize the main objection to such an allowance would be fear of revenue loss, which would then impact the ability of counties to fund essential services, including schools. However, I think the guidelines for qualification for such an allowance would be sufficiently strict to limit the number of property owners who would qualify. The guidelines could include annual income limits, years of ownership, property values in the area of residence, percentage increase in property values from the previous year, and the indebtedness of a homeowner in the form of existing loans. In any case, if property taxes are sufficiently burdensome that they impact the homeowner's well-being or ability to even stay in the home, some form of tax relief is the right thing to do. I urge you to raise this issue and suggest that the legislature or governor take up this need with appropriate legislation. I will be passing along my ideas to the state legislators as well. Thank you for considering my input. Regards. That concludes that comment.
Thank you. Ms. Thompson, I see your hand up.
Yes, so we appreciate TR John submitting comments in response to yesterday's interview with Chairman Vasquez concerning the Taxpayer Bill of Rights in our agency. The commenter suggests that other factors be considered when handling property tax increases, such as their property owner's income. And we're happy to reach out to him to provide information on, the current property tax system and the limitations of Prop 13 as to increases in property assessed values for the 2% in the factored base year value each year, and also the 1% general property tax rate. There is some current law regarding exemptions that are available based on income, and those are the disabled veterans exemption. So those are certainly considered. Changes to existing California property tax law would require changes to the California Constitution through a voter approved proposition. We are happy to provide some information to him about Proposition 13, which was approved by the voters in 1978. So if that concludes my remarks as well.
Thank you. I see a hand from Ms. Stowers and the one from Member Gaines. Ms. Stowers, go ahead.
Thank you, Chairman Vasquez. Thank you, Ms. Thompson, and to the constituent and your concerns. Although not directly related, I wanted to bring up the property tax postponement program that allows homeowners who are seniors, disabled, or blind to defer their current year property tax on their principal residence. There's certain criteria, and one being in that you must have at least 40% equity in your home, and your household income must be at a certain threshold. This might provide some relief, and I recommend that you go to the state controller's page, keyword search property tax postponement, and you can find additional information. We will be accepting the application for this postponement starting September 1st. And Ms. Thompson, when you reach out, I would appreciate it if you can follow your regular protocol and provide information on the property tax postponement, or at least a website link. Thank you.
Thank you. Member Gaines.
Yeah, thank you, Chair Vasquez. I just wanted to kind of emphasize the comments that have been made, because the purpose of Prop 13 was to protect property owners, and in particular, we're talking about a homeowner in this case. And we've got to figure out how to fix Prop 19, and that was an initiative passed by the people, but I know that there's been an effort by Assemblyman Kiley with ACA 9, or maybe it's an initiative that just goes to the people to correct this this aspect between children and grandchildren, because I'm just looking at another example here. this is an email from Trisha Gonzalez, and she's kind of laying out the same issue that can't afford these tax increases. And she says, I'm from a working class family who's been devastated by Prop 19. Prop 19 doesn't consider families with multiple children. Prop 19 doesn't consider families with modest homes in working class neighborhoods that are no longer affordable due to the pandemic causing a high rise in real estate in the last year. Due to Prop 19 changes, families are forced to choose which child receives the Prop 13 benefit and which ones do not. We are not landlords. We plan on staying in these homes. My husband's parents bought the second home that we have rented for 20 years with the plan that we can take over the home. The home still has a mortgage. With reassessment, we can no longer afford to live in the home. Additionally, Prop 19 was implemented on February 16th of 2021, 3 months to make family decisions when we could not meet due to the pandemic. We ask that you adjust Prop 19 or families like ours will be forced to move out of the state. And that's where it really hits the nail on the head, in my view, where you've got folks where the reassessment will make the difference as to whether they can maintain that house or not, and maybe even a bigger decision as to whether they can continue to live in the state. And I think we ought to continue to figure out ways to fix it. And many of you have talked about this too, as members of the Board of Equalization, but it just reiterates again that I think there's going to continue to be pain, because from what I've read, it's like 40 to 60,000 families are impacted by this every year as family members pass away. So I just want to throw that out again, and it'd be nice if we can figure out, maybe we would be able to sponsor something as members of the board if we could get agreement on what the fix should be for Prop 19. Obviously, the first element of Prop 19 is good because you have that ability to take base year value and transfer it to any county in the state. But this other side that takes away the ability to pass that property on to a child or grandchild, I think is hurting a lot more people than we realize. Thank you.
No, I echo those comments. You're right on point. And I'm hearing that as I go in more, especially as I participate in other meetings and receptions. That's the one thing that comes up when they find out I'm from the BOE. They said, how do we change Prop 19? That's going to be the challenge. With that, seeing no other hands, Ms. Taylor, who do we have on the line? Or who's the next written comment?
Our
The next
next
written
written-
comment is from B. Stotzer. And Ms. Stotzer states, thank you for allowing me to provide public comment regarding Taxpayers Advocate Office, and in particular, the exemplary and professional assistance of Lisa Thompson, Chief, Taxpayers Rights Advocate Office, and the Chairman's staff. I serve as a board member of the New Economics for Women. NEW is a Latina nonprofit economic development organization that provides essential services such as housing, financial support, and economic development opportunities for low-income women and their families. I was asked to resolve a very difficult tax lien issue that the organization had been trying to address for several years for one of its properties, a community center in the San Fernando Valley of Los Angeles. The organization did not have the means to afford an attorney to appeal the BOE's determination. The property in question had received a charitable exemption for several years. NEW was denied the tax exemption for an incomplete application. Staff tried to resolve it, but with no resolution in sight, which resulted in a huge tax penalty and liability. I initially approached our representative, Chairman Anthony Vasquez, in 2018, whose patience and counsel I will be extremely grateful. He explained the options and asked his staff to assist me. Christine Kazad, in particular, spent an enormous amount of time in identifying if we indeed could appeal the incomplete application, and thus the denial for tax exemption for the years in question. She eventually connected me to Ms. Thompson. Ms. Thompson was extremely detailed in her research and provided documentation so that I could better understand what had happened and why we did not qualify for the exemption for the years in question. She was so responsive and enormously helpful, as I had a difficult duty to inform the board of BOE's processes and our options. Then the pandemic hit in the middle of seeking resolution with our tax collector. Everything seemed to stop during COVID. Despite the setback, both the chairman's staff and Ms. Thompson continue to be responsive and worked with the tax collector to provide the documentation necessary that explain the complexity of why the late payment penalties should be canceled. I am happy to report that in June 2021, the tax collector agreed to cancel penalties with payment due by the end of July. That payment was made, and so pleased to inform the board that the tax collector's office confirmed that they had processed property tax payment to satisfy the defaulted taxes and that the certificate of redemption was issued. This positive outcome, with late payment penalties being canceled, could not have happened without the help of Lisa Thompson. In addition, her office was invaluable, and we now know that they will continue to assist nonprofits, such as ours, who do not have the means to get legal counsel, to obtain our organizational clearance certificate, expediting the welfare exemption claim processing with our county tax assessor. If I can be of any assistance in helping others better understand the invaluable services BOE and the Taxpayers' Rights Advocate Office provides, I am at your services. Respectfully, B. Stotzer, Board Member, New Economics for Women.
Thank you. Yeah, actually, I actually got involved with that issue right at the beginning, and I passed it over to Ms. Thompson, and actually give kudos also to my legal folks. Chris did a great job with this and prepping it and passing it on to Ms. Thompson. And I wanted to also personally acknowledge and thank Ms. Thompson for all your work on this, because it's a great little nonprofit, and I was afraid they were going to go under with the taxes that they owed. Ms. Thompson, I see your hand up.
Yes, thank you. I just want to tell Ms. Stotzer that we appreciate her comments and for her kind words. We had assisted her organization, as she indicated earlier, with the welfare exemption and cancellation of penalties for late payment of property taxes. We were able to communicate among the various government agencies involved for her to submit the appropriate information to receive the welfare exemption, and then also to support cancellation of penalties from the tax collector's office. I think that was a positive outcome. We truly value the work of nonprofit organizations because they provide vital service to Californians here. So if there are any other nonprofit organizations that are having problems with any issues they may have with the assessment or collection of property taxes, we would be happy to assist them if they reach out to our office. Thank you.
Thank you again. With that, Ms. Taylor, who's the next written comment or speaker?
Yes, our final written comment is from Corrine Molrath. Hello, I am opposed to many aspects of Prop 19. This bill will significantly harm families. This bill did not take into consideration the many types of living arrangements in California. This bill is harming my family. Admittedly, I am not completely up to speed regarding the latest work being done to repair the damage that has been done by Prop 19, but I would like my story to be included as part of the discussion. Family farms often consist of multiple family residences, as does ours. We all live on the property. However, due to no fault of our own, property values have skyrocketed in Sonoma County. When our property was passed to us by our mother, we met all the rules of Prop 19 because we live on the farm. But due to high property values, the new property tax evaluation is far over the 1 million cap plus assessed value. The new property taxes are so high that we will no longer be able to afford to live on our own property. The property that was passed down from my grandfather will now have to be sold to some rich guy who could care less about our farm or our children or our children's children, all who also live with us on the farm because no one can afford to buy anything in Sonoma County or in California. Unfortunately, this will probably mean most of us will need to move out of state. What can be done? Remove the 1 million cap. That is a completely random number and does not represent the value of farmland homes in all California counties. This is an urgent matter for families in our county and across California. It has been my experience that the information regarding Proposition 19 was not widely distributed and people voted on it without having a deep understanding as to the impact to families and farms. I believe if the average person understood how harmful this proposition was to families and farmers, they would have never voted on it. I believe that we will see a follow-up bill that will change the negative effects of Proposition 19. If we don't, we will see many families moving out of California and many farms closing up shop. Do you have any data regarding the number of attendees? I'd also like to compliment Ms. Cohen and look forward to working with her on our tax issues in the future. And that concludes her comments.
Thank you. Thank you for your comment. Ms. Thompson, I see your hand up. Go ahead.
Yes, we appreciate Corinne's comments, and she's expressed concern about the provisions of Proposition 19 that was approved by the voters in November of 2020. That voter-approved initiative constitutional amendment did include provisions for the $1 million cap as to the maximum factored base year value that could be transferred. In order to change that or remove that cap, another constitutional amendment would would be required essentially and passed by the voters. So, thank you. We appreciate the comments.
Ms. Thompson, along those lines, I'm just, we're constantly hearing them. This one, once again, kind of reiterates the issue of these folks, whether it's a family farm or somebody's home that they want to keep in the family, but because of the reassessed value, in many cases, it might be forced to sell. The only way, well, I guess it sounds like I think you hit it again. It would take another constitutional amendment to change it. Because one of the things I was thinking, what if there's some way we could provide an exemption where the people could stay in their home or their farm paying the existing taxes, but upon the sale or the transfer of that property down the road, they would have to reimburse whatever the adjustment was that they haven't been paying over the years. I'm assuming that would take another constitutional amendment, right?
Yes, yes, I believe so. Yeah. So, but we are, we're, again, gearing up once implementing legislation for Proposition 19 has been passed with our agency's property tax rules adopted and approved through the Office of Administrative Law. We will be, the Taxpayer Rights Advocate Office will be drafting information sheets that are short, simple, clear to the point, that provides resources to taxpayers, so they're aware of, the provisions of Proposition 19 as far as exclusions or exemptions that may be available to them for property tax savings, and as well as, just understanding the availability of those.
Thank you. Ms. Taylor, I believe that concluded the written comments. Do we need to check with AT&T now on anybody that might be on the line?
Yes, we will. AT&T moderator, can you let us know if there is anyone who wants to make a public comment on this matter? Each caller will have up to 3 minutes to speak. For the record, a caller may provide their name.
Thank you. If you wish to make a comment, please press 1, then 0 at this time. Once again, if you wish to make a comment over the phone, please press 1, then 0 at this time. I currently have no comments in queue at this time.
Thank you. I see a hand from Ms. Stowers. Go ahead, Ms. Stowers.
Thank you, Chairman Vasquez. This has been a great conversation about property tax and the services that our taxpayer rights advocate provides. But let's talk about the alcoholic beverage tax, another program within our jurisdiction. I have 2 questions, Ms. Thompson. What type of advocate services did your office or CDTFA provide to the alcoholic beverage taxpayers? My second question is, since this program is being administered by CDTFA under a memo of understanding, what type of review do your office conduct to ensure the rights of taxpayers are being protected?
Okay, so as to the first question, during this past year, we have not had any contact from taxpayers on the alcoholic beverage tax. Historically, there has been little contact. Last year, just before the Taxpayer Bill of Rights hearing, I was contacted by I think it was CEO of an organization about some beverage, new beverages that they wanted to have. They wanted to have additional public resources available to them on how to complete a tax return. And so what we did was, we put her in contact with some individuals with CDTFA, and we indicated that if, they were having any other challenges or difficulty, that she could contact us, and we would coordinate with the CDTFA Taxpayer Rights Advocate Office to have anything resolved. But that has not been done. There are many publications that are published by CDTFA pertaining to the alcoholic beverage tax. So, so as to the second one, and it kind of comes over to the first, is if we were contacted by a person regarding the alcoholic beverage tax, we would coordinate with the Taxpayer Rights Advocate Office at that agency on that. And in that regard, we do have a memorandum of understanding with them to administer the certain aspects of the alcoholic beverage tax program with that is under our agency's responsibilities. So, both of our agencies have information about the alcoholic beverage tax on them as well.
So are you confident that the requirements under RTC 32461 regarding education and outreach forms and et cetera for newly registered taxpayers, that is being carried out by CDTFA? Are you seeing these publications?
Yeah, they're they're posted to to the website. So, but we're happy to look into it further to see. I mean, if as they're posting it. But yes, I've reviewed their website to see their different publications. They have many tax programs, and we can
I
even provide another link.
I appreciate that. I think I'd be a little bit more comfortable, since this is our program, if we had a little bit more active role and a little bit more oversight over it. I would hate for something to fall through the cracks. So if you could just I know we have a handshake with them and you speak with them, but just take a look at it and make sure that everything is running smoothly from the advocate perspective.
Right. No, I'll definitely do that.
If that's okay with your director.
Yeah, I'll work with them. I know that I don't, and the Taxpayer Rights Advocate Office doesn't, but I know there are other staff in our agency, that monitors CDTFA's work in the alcoholic beverage tax. Reports are provided and other information and reviewed. So that is done. But from the point of advocacy on taxpayers, I'm happy to do that. Thank you.
Okay, thank you.
Thank you. I see another hand from Member Gaines.
Yeah, I think Member Stowers and I are thinking along the same tracks. I just sent a text over about half an hour ago, just asking Brenda, our executive director, if we could get more information and regular updates in terms of what is happening with the alcohol tax, but also the gross premium tax, because these are responsibilities that fall under our purview, but we never hear anything about them. And I realize that the CDTFA has taken on that responsibility, but I got the impression that that was going to be temporary, and that as we've staffed up the BOE, we're making great progress in that area. I think we ought to consider taking on those responsibilities. And so it'd be nice to have that discussion. Maybe, my suggestion is if we could put it onto a future agenda. I realize the taxpayer rights advocate role here, and that's critical, but just oversight. We've talked about other areas where we want further oversight as members of the BOE. And I think these two particular programs ought to be included.
No, that's a good point. I agree with that. I don't know if Ms. Thompson, is that an old hand, Ms. Thompson? I think you're muted there.
Sorry, it is. Yes.
It is.
Okay.
Okay.
And I'll just, thank you.
No, I agree with you, Member Gaines. I think we should, let's talk about that and see how we formulate that to put it on our agenda.
That's great. Thank you.
Ms. Taylor, do we have, we already said there was no other folks on the line at this point.
Correct.
And seeing no other hands or comments at this point, I just wanted to, once again, thank you for your team, especially Ms. Thompson, for a great job. I think this annual report provided a valuable overview and our progress in making our services better and improving our taxpayers' experience. And in listening, especially to the written comments that came in today, and even some of the folks on the line, for the most part, usually you do these hearings, and I'm used to, being in a local city where you're sitting there at the dais and everybody that comes to testify usually is complaining about your staff. And so it's kind of refreshing to hear people, at least written and publicly, actually giving you praise. So kudos to Ms. Thompson and your staff for putting together this great report and just for all the work you're doing that is helping a lot of these taxpayers, not only the residential folks, but as we heard, also the nonprofit world, which, I come out of, I used to run a nonprofit, and many times, you're working with boards and staff that are not really experienced to handle a lot of these reporting mechanisms, and they fall back on their taxes. And in many cases, it's to their detriment, and they end up having to close up shop. And at the end of the day, the community is one that loses because whatever service they were providing is no longer available. So thank you for all your help and your work along those lines. With that, I'm getting a request from one of our members that if we could take maybe a 15-minute break. Is that good with everybody before we get into our next item? And then we can come back and go on to C2. I see heads nodding. I think we're okay. So I have, I have 12:55. Why don't we say, or actually 11:56 right now. Why don't we say about 12:10, we'll reconvene. Is that good? I'm seeing heads nodding, waves. Okay, so we'll come back at 12:10.
Sorry, I missed that. Could you say it again, please?
Oh, who's that?
That was Siri.
Vice Chair.
Vice Chair Schaefer, go ahead. I'm sorry.
Before we leave, I was looking at the California Taxpayers Bill of Rights excerpts dealing with alcoholic beverage tax law, and this is a 1992 statute, and that was almost 30 years ago. We have $500 and $7,500 amounts listed as to when it's a big deal or a smaller deal, or when it can be settled simpler, depending on the amount. Are these figures over 30 years frozen, or has it been changed, but it doesn't appear in the material that I've read? I'd like to think that the easy handling of a matter, if it used to be $500, maybe it might be $1,000 today. Who looks at that? Do we wait until the legislator does, or maybe Ms. Thompson has a chance to do that?
So,
Ms. Thompson, go ahead.
Yeah, so the California Taxpayer Bill of Rights, actually in our Taxpayer Rights Advocate annual report, there's two appendixes, and one of them includes the property tax, Morgan property tax Bill of Rights provisions, and then the other one contains the California Taxpayer Bill of Rights provisions that's applicable to our agencies, and the alcoholic beverage tax is one of them. So that is included in that. And yes, in the 90s was when those Bill of Rights provisions were first in place, and they do have those. We look to see if statutory changes have been made to those code sections from that point forward, and if they are, we reflect those in the changes. So there are certain provisions that may have been updated. So the dollar amounts should have been, could have been updated by statute. I would have to look at them to see. I'm happy to do that and reach out to you and let you know. But yes, those would require a statutory change in order to make those changes. So
thank you. I'd appreciate you looking into that. And if we find that they've been asleep at the switch for 30 years and haven't done anything, then I'd like a little memorandum to support my asking the legislature or whoever would be involved, or some committee, to argue for that. I'd even appear and speak when we return to Sacramento. Thank you.
Okay, so I'll be happy to reach out to you and give you that information, and you can proceed forward.
Chairman Vasquez and members, again, this is Brenda Fleming, the Executive Director. Vice Chair Schaefer, thank you so much for your comments, and members, all of the comments on these additional tax programs. What I'd like to offer for you, and consistent with what you're asking, is for staff to come back and do a comprehensive update and presentation on both the alcoholic beverage tax program and the tax on insurers. And then I think it's good public discussion to drill down on both of those programs a little bit more. So one, you're informed about what the programs are and our responsibilities, including the oversight for our service provider, CDTFA, for the collection of the tax portions of it and the redetermination roles. But really so that we're clear on what their roles are as sort of contractors for us for that service and what our role is, and then we can come back and look at what we need to do to modernize those tax programs also. So if you would, just allow us the opportunity to come back, and I'll work with the chairman's office to schedule an upcoming hearing on that matter so that we can drill down it a lot more. We might even consider whether or not we want to include it as a part of a recurring report on our PAN. So if you would allow the staff to have a little time to be prepared for a more in-depth discussion, we would greatly appreciate it. Thank you, members.
Thank you. I think that's a good suggestion. With that, members, actually now we're at 12 o'clock, so we'll reconvene at 12:15. We'll take a 15-minute break. 12:15 we'll reconvene. Thank you all, and we'll see you in a bit. Members, let's go ahead and get started because I know we have a lot to cover still. And then we also have to try to work in our constitutional officer, Ms. Betty Yee as well, the controller. So with that, Ms. Taylor, if you would please call the next item.
Excuse me, Chair Vasquez.
Oh, Vice Chair Schaefer, yes, go ahead.
I want to apologize for being a bit late. I just assumed you would go ahead with your quorum, but I was wrong. If there was any inconvenience, I apologize.
Not a problem. Thank you.
Thank you.
Okay. Ms. Taylor, if you would please call our next item.
Our next item is C2, Public Hearings, Proposed Property Tax Rule 462.540. Public hearing and proposed adoption of Property Tax Rule 462.540, change in ownership, base year value transfers, to implement and make specific provisions of Section 2.1 of Article 13A of the California Constitution. This matter will be presented by Mr. Moon.
Good afternoon, Chair Vasquez, members of the board. This is the public hearing for proposed property tax rule 462.540, change in ownership base year value transfers, which will offer an opportunity to the public to make comments on the proposed rule. Following the public comment, the board will have an opportunity to formally adopt the rule. As you know, since the passage of Proposition 19 in November of last year, we've been working to provide guidance to assessors as well as other stakeholders regarding its new requirements. Part of the guidance process has been drafting new regulations that clarify certain aspects of the process. And we've divided the rulemaking process into two parts, one covering each of the main property tax portions of the law, the intergenerational transfer exclusion and the base year value transfer. The intent of the rulemaking was to timely clarify some of the major issues raised by Prop 19.1. At the May 25th meeting, the board authorized publication of Rule 462.540, the new proposed rule explaining aspects of Prop 19 base year value transfer. Again, following today's public comment, the board will have the opportunity to adopt the rule. Should the board do so, staff will then prepare the final document to go to both the Office of Administrative Law and the Department of Finance for final publication of the. If you have any questions prior to hearing public comment, I'd be happy to.
You know, Mr. Moon, I'm getting a little bit of a back vibration back there, so it's not real clear. And I don't know if you're on a speakerphone or what the situation is, but I'm assuming you're finished with your comments.
I apologize. Yes, I apologize. I didn't realize I was breaking in and out. Is this better?
That's a lot better.
Yeah, I'd be happy to review anything that I may have broken up on and wasn't able to be heard. But essentially, I had just wanted to inform the board that that this is a public hearing where the public will be allowed to make comments on the rule, and then following the public comments, the board will have the opportunity to adopt the proposed rule.
You're muted, Mr. Chair. You're muted.
Oh, thank you. I'm sorry. Mr. Moon, were you going to state the actual article? I mean, you know, I kind of lost you there.
Oh, yes. It's proposed property tax rule 462.540, which is titled Change in Ownership, Base Share Value Transfers.
Thank you. With that, Ms. Taylor, or unless I don't see any hands or comments from anybody, Ms. Taylor, can we check to see if we have anybody that wishes to make a comment, public comment on this?
Certainly, I could start with a written comment and then we could go
Sure.
to AT&T. All right. Our first written comment is from Trisha Gonzalez. I come from a working class family who has been devastated by Proposition 19. Prop 19 doesn't consider families with multiple children. Prop 19 doesn't consider families with modest homes in working class neighborhoods that are no longer affordable due to the pandemic causing high rise in real estate this past year. Due to Prop 19 changes, families are forced to choose which child receives the Prop 13 benefit and which ones do not. We are not landlords. We plan on staying in these homes. My husband's parents bought a second home that we have rented for 20 years with the plan that we can take over the home. The home still has a mortgage. With reassessment, now we can no longer afford to live in the home. Additionally, Prop 19 was implemented on February 16th, 2021, 3 months to make family decisions when we could meet due to the pandemic. We ask you to adjust Prop 19 or families like ours will be forced to move out of state. And that concludes the written comments. AT&T moderator, can you let us know if there is anyone on the line who wishes to comment on this rule? For the record, they may provide their name.
Thank you. If you wish to make a comment, please press 1, then 0 at this time. I currently have no lines in queue at this time.
Thank you. And thank you, Mr. Moon. One question. Are there any stakeholder concerns brought forward that this rule hasn't addressed?
Chair Vasquez, the intent of the proposed rule was not to address every potential concern that could be raised by stakeholders. Rather, it was to provide guidance for some of the larger questions that were raised by Prop 19's base year value provisions. Thus, there are questions and issues and factual circumstances that these rules do not address. And we would anticipate that we'll be providing additional guidance in the future in various forms, LTAs, legal opinions, and if necessary, amendments to these rules. And we'd anticipate that additional guidance will be going on for quite some time. So for example, for the Prop 58 parent-child exclusion that was passed in 1986, we've been answering questions and providing guidance on that for the past about 30 years. And so I would anticipate that we will be providing guidance addressing specific situations and issues not addressed by these rules far into the future.
Thank you. Members, do we have any questions of Mr. Moon or of this item? Seeing no hands or comments, let's proceed with, if we can just proceed with the motion to adopt the proposed rule. And the motion should be to adopt proposed rule 462.540 as reflected in the materials attached to the pan under this item.
So moved. Or
It's been moved by Member Gaines. Is that a hand or a second by Ms. Cohen?
It's actually a hand, but I can ask Mr. Moon my question after we take our vote.
Thank you. So that's a second there. Ms. Taylor, if you please call the roll.
Certainly. The motion is to adopt staff's recommendation to adopt proposed rule 462.540 as reflected in the materials attached to the public agenda notice under this item. Chairman Vasquez.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
aye.
Member Cohen.
Aye.
Deputy Controller Stowers.
Aye.
So that's unanimous of all those present. And then Member Cohen, I believe, had a question for Mr. Moon.
Thank
Oh,
you.
a comment.
I
Oh, you're good.
I don't have a comment or a question. Thank you.
Oh, okay. Thank you. With that, Ms. Taylor, if you would please call our next item.
Our next item on the schedule is D3. Are we planning to hold that until 1 p.m. for the controller?
Yes, we want to hold that. And I believe we can skip the next two and go to, I believe it's J, is it J1?
Certainly. The next item is J1, Administrative Consent Agenda, Adoption of the Board Meeting Minutes for July 27th, 2021. Contribution disclosure forms are not required pursuant to Government Code Section 15626.
Thank you, Ms. Taylor. Members, do we have any questions or comments of these minutes? Seeing and hearing none. Ms. Taylor, do we have any public comments on the minutes or written, or can we check with AT&T?
We have no comments, but I'll check with the AT&T moderator. AT&T moderator, can you let us know if there is anyone who wants to make a public comment on this matter? Each caller will have up to 3 minutes to speak, and for the record, a caller may provide their name.
Thank you. If you wish to make a comment, please press 1, then 0 at this time. I have no comments in queue at this time.
Thank you. With that, members, I'd like to entertain a motion to approve our minutes of July 27th, 2021.
This is Deputy Controller Stowers. I move that we approve the minutes of July 22nd, 2021. I get the date right. July 27th.
27th, right? Yeah, okay.
Second.
So it's been moved by Ms. Stowers and second by Member Gaines. And seeing no other hands or comments, Ms. Taylor, if we can call the roll on that.
All right, the motion is to approve the minutes as presented. Chairman Vasquez.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
Aye.
Member Cohen.
I'm here. Aye.
How do you vote?
Oh, you're muted. Okay.
Aye.
Thank you.
Thank you.
Deputy Controller Stowers.
Aye.
So that's unanimous of all those present. With that, Ms. Taylor, if you would call the next item.
The next item is J2, Invitation to the Annual Meeting of the Board and County Assessors. Request approval to invite county assessors to meet with the State Board of Equalization and discuss issues relating to property assessment administration. The meeting may be virtual pending status of the pandemic cases.
Thank you, Ms. Taylor. Members, for the care and safety of the state staff and public, and due to the uncertainty surrounding the COVID-19 pandemic, at this time, we anticipate that this October meeting may need to be conducted remotely. Additionally, we have received feedback from many assessors that they would prefer this year's annual meeting be held remotely. However, we will continue to monitor the situation. As you are aware, we have the capacity to hold this meeting remotely using video and teleconference systems. Similar to last year, we would prepare for a public portion with the board members and the CAA, and then individual breakout sessions for each districts. Members, do you have any comments or questions on this?
The chair, Vice Chair.
Vice Chair Schaefer, yes, go ahead.
Yes, Chair Vasquez, we expect to be in Sacramento in October, I understand. Does that affect in any way whether this meeting would be virtual or not?
Well, if we're in Sacramento, then we'll probably be able to do it in person. But I think we're kind of reserving or holding back because we're seeing this activity with this new Delta still kind of out there, and it seems to keep spiking. So we just kind of want to have that flexibility.
Well, I miss the opportunity to see my colleagues, and I miss the opportunity to see our assessors. So
I'm with you on that one.
Thank you.
Member Stowers, I see a hand up there.
Thank you, Chair Vasquez. So are you saying that we have the ability to have it 4 separate breakouts with our telecommunication?
We're going to be in Sacramento.
So that, I'm getting feedback.
Yeah.
So that.
Yeah, Member Schaefer, Vice Chair Schaefer, you might want to mute your mic. Mute your mic, Vice Chair Schaefer. Thank you. Okay, Ms. Stowers, go ahead.
So we do have the capability to have 4 separate breakouts by districts so that each elected official, each district member can meet with their county assessors separately, because I understand, and that part is not generally a public meeting. That's generally just between the assessors and the district member.
That's my understanding. Yes.
Okay.
Any other comments, questions? Seeing and hearing none. Ms. Taylor, do we have any written or public comments on this item?
We do not have any written comments. I can reach
check
out
with
to
AT&T.
Certainly. AT&T moderator, can you let us know if there is anyone who wants to make a public comment on this matter? Each caller will have up to 3 minutes to speak. For the record, a caller may provide their name.
Thank you. If you wish to make a comment, please press 1, then 0 at this time. I currently have no comments in queue.
Thank you. Members, do I hear a motion to approve this invitation? I see Ms. Stowers.
Yes, Deputy Controller Stowers, I move that we approve the invitation to invite the assessors to meet with the board members on October 19th, which may or may not be virtual, depending on the circumstances.
Second.
It's been moved and seconded by Member Gaines. Seeing no hands or comments or questions, Ms. Taylor, if you'd please call the roll on that motion.
Certainly. Chairman Vasquez?
Aye.
Vice Chair Schaefer?
Aye.
Member Gaines?
Aye.
Member Cohen?
Aye.
Deputy Controller Stowers?
Aye.
So that's unanimous of all those present. Ms. Taylor, it's my understanding that the Controller Betty Yee has joined us. So I believe we can go now to our constitutional functions, D3.
Thank you.
And welcome, I see you on the screen now. Welcome, Controller.
Good afternoon, Mr. Chair. Thank you.
Great to see you.
You too.
The next.
Okay, Ms. Taylor.
Thank you. Our next order of business will be D3, Tax Program Non-Appearance Matters, Consent, Legal Appeals, Property Tax Matters, Applications for Review, Equalization, and Adjustment under the California Constitution, Article 13, Section 11. Confidential contribution disclosure forms are not required for this matter. This is a constitutional function. D3A, Woodland Davis Clean Water Agency for Review, Equalization and Adjustment of Assessments in Yolo County, Appeals Number ARA 17-001, 2016 through 2017, ARA 18-001, 2017 to 2018, ARA 1800-002, 2018 to 2019, ARA 19-001, 2019 to 2020, CF. This matter will be presented by Ms. Yim.
Thank you. Is Ms. Yim available?
Yes, I'm available. Good
Please
afternoon,
proceed.
Chairman Vasquez, and yes, good afternoon, Chairman Vasquez and honorable members of the board. I'm Sonia Yim, the appeals attorney assigned to the matter before you. These are 4 Section 11 petitions which were filed each year for fiscal years 2016 to 2020, and they have been consolidated. They are now before the board, consistent with the board's authority to review, equalize, and adjust the value of taxable property owned by a public entity outside of its boundaries. Here, the parties reached an agreement in 2020 resolving all issues in the consolidated petition. Specifically, the parties have agreed that the applicant's property is now within the jurisdictional boundaries of the applicant and therefore exempt from property taxation, and as such, the parties agree the correct assessed value of the applicant's property is 0 for each of the assessment years at issue. Based on the foregoing, the appeals attorney recommends that the board adopt the parties' agreed to assessable value of 0 for each of the lien dates at issue in the consolidated petition. I ask for your adoption of the appeals attorney's recommendation. Thank you.
Thank you. I have just a procedural question that doesn't affect the substance of the appeal, but I guess my question is, this matter, I guess, this water agency and the county has been pending for like 4 years. Is that an average time frame for these court appeals?
I would say that this is not a court appeal, and not all of the petitions have been pending for 4 years. They've been filed each year until fiscal year 2020. However, I can provide some other general remarks about our appeals process. For example, in general, staff are in regular contact with the parties whenever a petition is filed, and typically cases are only stayed when the parties request a joint stay from our chief counsel. And generally, our staff will accommodate the parties' request for a stay when it will help facilitate resolution of cases and avoid protracted litigation. And that litigation could either be between the parties or it could be a result of the board's decision in a case. But in any case, staff does stay in regular contact with the parties and ensures that the stays that they requested are continuing to be the will of the parties, and we ensure that the parties are moving toward resolution expeditiously.
Thank you. Members, do we have any procedural questions or comments for Ms. Yim?
Mr. Chairman, I have a question.
Yes, go ahead, Controller.
Thank you very much. First of all, I really applaud the parties for coming to resolution on this matter. And I think my only procedural question has to do with the timing, where the agreement was reached in 2020, but we've got years at issue prior to that. And I get the practical effect of what would happen if these properties were subject to tax, but Are we essentially just honoring the agreement of the respective parties that are part of this joint agency as it relates to all years, or are there statutory, I guess, kinds of considerations that we need to think about relative to the prior years before the agreement was reached?
I believe we are respecting the agreement that the parties came to, which affects the years that they filed appeals for.
Okay, so their agreement is encompassing all of the prior years, and their elegant resolution with now the county joining just essentially has the property now within the boundaries of the entity, right?
Yes, that's correct.
Okay. All right. Thank you. Thank you, Mr. Chair.
Thank you. Any other comments, questions?
Chair Vasquez, this is
Member Gaines. Member
Yeah,
Gaines, go ahead.
Just to clarify to make sure I understand this correctly. So this was a JPA set up with Woodland and Davis, and to resolve and then to resolve the tax issue at hand, it included the addition of Yolo County. Is that correct?
Yes, that's correct.
Okay, just so I understood that. Thank you.
Thank you. Any other comments, questions? Seeing and hearing none. If there are no other further comments, members, do we have a motion to adopt the staff's recommendation for settling these appeals?
Mr. Chairman, yeah, I'll second.
Okay, it's been moved and second by the controller. Seeing no other hands, Ms. Taylor, if you please call the roll on that motion.
Would we like to take public comment before I call
I'm
the roll?
sorry. Yes.
Thank you. AT&T moderator, can you let us know if there is anyone who would like to make a public comment on this matter? Each caller will have up to 3 minutes to speak. For the record, a caller may provide their name.
Thank you. Ladies and gentlemen, if you wish to make a comment, please press 1, then 0. That's 1, then 0 to make a comment. And at this time, we have no one in queue.
Thank you.
Thank you. Ms. Taylor, if you would now please call the roll.
Okay. The motion is for the board to adopt the parties agreed to assessable value of 0 for each of the lien dates at issue in the consolidated petition. Chairman Vasquez.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
Aye.
Member Cohen.
Aye.
Controller Yee.
Aye.
So that's unanimous of all those present. With that, I just would like to just make one final comment that, as a board, I guess more on the procedural matters, we can't control the time court takes on some of these appeals. But at the end of the day, as a chair, I'd like to make sure that we stay on top of these and hopefully do a better job of monitoring these appeals. Because to me, it just seems, well, even though Ms. Yem, I guess, mentioned that it wasn't as long as 4 years, but still, I think some of these usually are pretty lengthy. With that, Ms. Taylor, if you would please call our next item.
Our next item is B3 Tax Program Non-Appearance Matters, Adjudicatory, Legal Appeals, Property Tax Matters, Petitions for Penalty Abatement on Private Railroad Car Tax. 3A, the Procter & Gamble Manufacturing Company, number 5891, PCP 21-003, CF. 3B, Trinseo LLC, 6529, PCP 21-001, CF. 3C, Blue Cube Operations LLC, 6590, PCP 21-002, CF. Contribution disclosure forms are required pursuant to Government Code Section 15626. Contribution disclosure forms were received prior to the beginning of the board meeting. This is a constitutional function. This matter will be presented by Ms. Garrett.
Thank you. Is Ms. Garrett available?
Yes. Good afternoon, Chairman Vasquez and honorable members of the board. As Ms. Taylor mentioned, I am Sarah Garrett, the appeals attorney assigned to the 3 cases under today's E3 calendar. The 3 separate petitions mentioned are private railroad car tax penalty abatement petitions with the same questions of law and similar facts. Accordingly, my remarks will cover all 3 petitions. Here, each petitioner paid their private railroad car tax late, but sufficiently timely to qualify for abatement, provided that a petition is filed that establishes reasonable cause to the satisfaction of the board. However, each petition at issue was filed outside of the time period required. Nevertheless, the board has the authority to extend the deadline for timely filing the instant petitions by up to 30 days if good cause is shown. Here, the conditions of the COVID-19 pandemic are cited for both good cause and reasonable cause purposes in each petition. Additionally, if the board grants an extension of time to each petitioner, the State Assessed Properties Division and each petitioner are in agreement with the penalty abatement recommendation before the board. Accordingly, the appeals attorney recommends that the board grants an extension of time under Government Code 15620 until February 23, 2021 to timely file the Procter & Gamble Manufacturing Company, Turnsale LLC, and Blue Cube Operations LLC petitions due to the good cause conditions of the COVID-19 pandemic. And then also grant each petition abating the penalty, interest, and related recovery fees, as each petitioner's late payment was due to the reasonable cause stemming from the unique challenges of the COVID-19 pandemic. I ask for your adoption.
Thank you. Thank you, Ms. Garrett. Members, do we have any comments or questions for Ms. Garrett? Seeing and hearing none.
Mr. Chairman, I have one. I'm sorry.
Oh, I'm sorry. Go ahead. Go ahead, Madam Controller.
It speaks to the current Government Code Section 15620. I know that for these 3 matters before us, the timeliness related to the pandemic, and I just wanted to be sure that that Government Code section was pretty clear with respect to the various factors by which we would look at granting an extension of time.
Thank you, Controller Yee. So under 15620, good cause is needed that satisfies the board, and in this instance, staff's recommendation is to grant the extension of time for each petitioner.
So there's not a definition of what good cause or reasonable cause is in the statute itself?
No, it is the board's pleasure.
Okay. Thank you.
Thank you. With that, seeing no other comments or questions, Ms. Taylor, do we have any written comments on this?
We do not have any written comments.
Can we check with AT&T and see if anybody on the line that wishes to speak on this?
Certainly. AT&T moderator, can you let us know if there is anyone who wants to make a public comment on this matter? Each caller will have up to 3 minutes to speak. For the record, a caller may provide their name.
Thank you, ma'am. Please press 1, then 0 if you wish to make a comment. That's 1, then 0 if you wish to make a comment. And there is no one in queue at this time.
Thank you. Members, this item is now before us. I'd like to entertain a motion to approve this matter.
I'll move to adopt the appeals attorney's recommendation.
I
It's
second
been
the
moved by our
motion.
controller and it's been seconded by our Vice Chair Schaefer. Seeing no other hands or comments, Ms. Taylor, if you'd please call the roll on the motion.
Certainly. The motion is to approve the staff's recommendation. Chairman Vasquez.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
Aye.
Member Cohen.
Aye.
Controller Yee.
Aye.
So that's unanimous of all those present. With that, Ms. Taylor, I believe that concludes our constitutional responsibilities, correct?
Correct.
And I believe, Controller, you're welcome to stay, but I believe you're probably off to another meeting or another commission, I'm sure.
I am. Thank you. It's great to see everyone. Thank you for your indulgence. Appreciate
No,
it.
thank you.
All right.
And you came in at perfect time. I thought we were going to have to hold off a little bit.
All right. Good.
Your
Take care,
timing was
everyone.
perfect.
Okay. Thank you, Mr. Chairman.
Thank you. With that, Ms. Taylor, I believe we're getting ready to go into closed session. Is that correct?
That is correct.
Chairman Vasquez and members, this is Brenda Fleming, Executive Director. At this time, members, if you recall, sir, we will be taking up closed session specifically at 3 p.m. today.
Oh, so do we don't have any other items on the agenda, do we?
We do
No,
not.
not at this time, sir. So what we would do at this point would be take a recess. If members wanted to enjoy the pleasure of maybe a lunch out of today's hearings, and then we would reconvene the regular meeting a little bit before 3 o'clock, and then we would immediately go into closed session for some confidential briefings, and then follow the normal processes after the closed session.
All right. So we don't actually adjourn the meeting there. We're just going to put it on hold. Is that correct?
No, sir. You would do a recess at this
Oh,
point.
recess.
We'll recess for a lunch break. We'll recess for a lunch break, and then we'll reconvene. How about we reconvene at about 2:55?
Why don't we say 2:50?
Okay, sounds good. Thank you. Thank you,
All right.
members.
So we will go ahead and take a recess take a lunch break until 2:50, and then we'll reconvene. If we can have everybody come back promptly at 2:50, and then we'll go ahead into our closed session. Thank you all, and we'll see you in a bit.
But we're not going to do that.
Enjoy your lunch.